Hi everyone, you are welcome once again to Macmedia channel. For those who watched our last video captioned the telephone call that stopped cross-examination and adjourned Mazi Nnamdi Kanu's case further in Nigeria. That was yesterday, Monday, 5th May 2025. Today being 6th May 2025, has proved there was a telephone communication of which the former Minister of Justice and Attorney General of Nigeria, Abubakar Malami, had been proved today being 6th of May 2025 during the court proceedings. Do not fail please to subscribe to this channel. Your thumb up is highly needed. Again, this video is purely made for the lawyers of Mazi Nnamdi Kanu, the legal representative. Let us continue. There is no doubt that former Justice Minister Abubakar Malami interrupted today's proceedings. Interruption is meant to further his actions against Mazi Nnamdi Kanu after he introduced a new letter from the back through the prosecution lead counsel and the senior advocate of Nigeria, Amolo. Quote from the report stated, however, attempts by the prosecution to tender a letter authorizing the witnesses' investigation met stiff resistance from Agabi, who objected on the ground that the document was not front-loaded, which prompted the prosecution to withdraw the document, unquote. Again, the proceedings was interrupted and shifted to a new date. This proved the point Macmedia made yesterday being Monday, 5th of May 2025. The aim was only to strengthen the witness of Pwbbb as they watched the defense counsel Agabi trash the evidence of AAA before the court. This prompted Abubakar Malami to intervene and try to produce evidence he believed will be stronger and make his case more incriminating against Mazi Nnamdi Kanu. This criminal act and behavioral attitude of the minister had swiftly distorted the proceedings. Let us go back to see his previous actions as Minister of Justice in Nigeria. According to his Wikipedia, Abubakar Malami, who is a Fulani Muslim, born on 17th April 1967 in Brenin, Kebbi, Nigeria. His secondary school was in College of Arts and Arabic Studies and graduated from Osman Danfodio University in 1992. On 11th November 2015, Abubakar was appointed as Minister for Justice and the Attorney General of the Federal Republic of Nigeria, the youngest minister in Muhammad Buhari's cabinet, unquote. He is a member of SAN, Senior Advocate of Nigeria, but in June 2019, he appeared before a disciplinary panel of the Legal Practitioners Privilege Committee to face the petition seeking the stripping of his senior advocate of Nigeria rank for alleged misconduct, unquote. However, this was dismissed due to procedural issues on the part of the claimant, unquote. This is the same Abubakar Malami is repeating in the trial of Mazi Nnamdi Kanu. He failed the procedural method of submission of documents after being the Attorney General of the Federation and also Senior Advocate of Nigeria. This reminds us of the BBC Pidgin English publication of 29th June 2021, in which they stated, quote, Justice Minister Abubakar Malami say them don't repatriate alias return Kanu to Nigeria, unquote. The title of this publication was Nnamdi Kanu arrested, IPOB leader arrest, extradition to Nigeria as Biafra separatist, unquote. Unfortunately, the Justice Minister did not know how to make application for extradition of persons or citizens, perhaps wanted from abroad by a Nigerian government. That's what he has to do, make application to the country where the victim is for extradition back to Nigeria. But what they knew from his masters, Muhammad Buhari, expert in international terrorism, to apply terrorist method of abduction and rendition to capture their victims, not through the normal process of extradition, rather through terroristic method of abduction rather than the judicial process. This video is for the defense team. Going back to the submission of the unwarranted and inadmissible letter and the video submitted via prosecution counsel by Malami Abubakar. However, the defense team led by senior counsel Agabi SAN resisted this, and the Mazi Nnamdi Kanu himself, who knew the law, who knows what to do, and who can make his own personal decision based on what he knew from the law and what he has observed from other legal proceedings, especially in criminal trials, vehemently resisted this also. Please, whoever that received this video and knows how to communicate it and post it to the defense team, all of them, from the lead counsel to the least of them, so that they will be able to access this video. Please. Again, much credit will be given to the judge, who also objected and detected the procedural errors which the former Attorney General of the Federation, Malami, wanted to use the prosecution lead counsel to commit. One will remember that in 2019, it is this procedural error of the claimant who made petition against him that made the judge to dismiss the case. And he himself, Malami, is using the same procedural error to tackle another victim of their abduction, Mazi Nnamdi Kanu. This is a credit to the judge, and Macmedia wish to remind the judge that when a case is properly treated, errors detected, all the tricks of the prosecution identified, and the case properly dismissed, that he can be able to travel to Western countries, especially the United States, who are watching, the European Union country members, the United Nations Human Rights Group, through the chief, Mr. Fox, and the International Criminal Court judges. All these groups are the group that can recommend you to further your career at international level when the conduct of the proceedings and management are observed as being free and fair. This eliminates the judge from the abuse of process and places him at the public confidence level in the administration of the justice. Therefore, Malami's statement, which he had opportunity from the time the case management began, submissions of statements and evidences began, he did not do so until the first Pwbbb witness evidence cross-examination failed their own test. Then he decided to do otherwise, to submit a statement which he is not part of the witness. Any statement submitted before the trial must comply with the requirements set out in practice direction of the court. Again, a witness statement may be used only for the purpose of the proceedings in which it is served. That is the procedural practice direction. Again, a witness statement which stands as evidence in chief is open to inspection during the course of the trial unless the court rules otherwise. This helps to improve the interest of justice and the public interest as well. These are the two factors the judges always are directed to observe. One is the interest of justice, and secondly, the public interest. Finally, there is always an affidavit accompanying any further statement made by the witness at a hearing. Finally, on the notice to admit facts, a party may serve notice on another party requiring him to admit the facts or the part of the case of the serving party specified in the notice. And where is that notice? The notice should be not less than 14 days before the trial. Now, when you look at Malami's letter and the video evidence, he had all the ample time to submit his evidence statement and video, not later than 21 days before the trial. This is exactly the procedural error his claimant did when he was petitioned and the court required to strip his senior advocate of Nigeria. But because the claimant did the same procedural error, the case was dismissed. It is within this very period that the court may allow a party to amend or withdraw any admission made by him on such terms as it thinks just. That is what the case is all about. Once again, this video program is to remind the defense team that the late disclosure of the Malami's evidence or letter and video which he had kept in his office supposed not to be admitted because he had all the ample time to do so as the Justice Minister. He began this case. He made a statement when Mazi Nnamdi Kanu was kidnapped and the rendition back to Nigeria. He told the world that they have been able to abducted their victim. Therefore, it is not admitted or admissible by the defense team. Anything outside the statement submitted, anything outside the evidence given, anything outside the materials other than what was submitted before the trial or 21 days before the trial, do not admit any of them. With this, we come to the end of this very program. We'll continue watching and observing how the judge will be treating the case, because he is paying watch not only by Nigerian public, but international community. And for the interest of justice, he has to be open irrespective of the frontiers. He is the judge. They thank you for being open and non-partisan, rejection of interference from any authority. Then you have your reward waiting for you at the international level. That is how it has been and will continue to be. You can recount how many Nigerian judges that have taken cases and discharged them creditably well that have jobs outside the Nigerian community. But the good news is that Mazi Nnamdi Kanu is represented by senior barristers and barristers from all over Nigeria. If you look at this, you see Kano Agabiv, SAN from Cross River State, Uchenna Njoko, SAN, Ebonyi State, Onyechi Ibazo, SAN, from Anambra State, Emeka Etiaba, SAN, from Anambra State, Mela Audu Nunge, SAN, from Gombe, and Dr. Joseph Akubo, SAN, from Benue State, and all others. They are there for Mazi Nnamdi Kanu. That is the good news. We wish to use this opportunity once again to thank all our new subscribers. We wish them well, and those who have not subscribed to this channel, we ask you to do so. We ask you to subscribe, like, share, and leave your comment. Thank you, and wait for our new video. Thank you very much, and God bless you. Bye.